It is time to check in with Chris Dimakos, our CJAD 800 legal contributor. Chris, a couple of really interesting stories. Now, I know last week we talked about a particular story, which I guess we're going to follow up on this one day and ask our listeners if it's ever happened to them. The idea that you could actually, lose your job because you show up to work too early. But I'll leave that aside. The story you have today, it's about an employee who was wrongfully dismissed, was entitled to severance, 2 years worth, right, by the courts. But then something happened that this employee failed to do, and this is now called all that into question. So let's get into this one.
Right, and just let's just start by telling everyone what the basic principle is. So if you get unjustly terminated from work, if you are let go and the employer was not in the right when they did so, well, then you're entitled to damages. And what the way that comes in, the form that it comes in, is basically, we call it severance, but it's in the form of notice. It's supposed to help you transition from one job to the other, to help you pay for your life between jobs. And the longer you work somewhere, the older you are, the more difficult the job market is, well, that number gets higher and higher and higher. So this individual went to court. This individual was justified in taking the employer to court, and everything was great, except for one thing. When he was let go, the time from when he let go until the time the judgment was rendered, there was about a year and a half that had elapsed. The employee who was fired didn't make any attempt to find another job, or not a sufficient attempt, let's just say. So there wasn't a paper trail of job applications and job interviews. And what the court said was, look, you were unjustly dismissed, but that doesn't mean that you get to just sit at home and relax. It's not a vacation pay. It's a transition salary, and you have to make efforts. You don't have to find a job. It's not a guarantee, but you at least have to make a sufficient effort to find a job. And they reduced the amount of severance based on the fact that the employee didn't make any credible effort to mitigate the damages suffered. So in this case, the employee who would have gotten the max amount had it reduced significantly because they didn't make any credible attempt to mitigate the damage and find another job.
Okay, first question, how would anyone have known if the severance is coming from your employer, your ex-employer at this point? Isn't that kind of one and done and forgotten about?
Not necessarily. So what happens when you go to court and you file a complaint is the tribunal first decides, well, were you let go with or without cause? And if it's without cause, okay, now we've got to put a number on this. What is that worth? That wrong that was done to you as an employee, how much are we going to give you? What represents an adequate parting package that allows you to, A, find another job and transition to that other job, and B, take care of any other damages that you suffered as a result of the termination. So in most cases, they put 1, 2, 3 weeks per year as a calculation, sometimes even 4 weeks per year of service. But if you are not making any attempt at all to find another job, no interviews, you didn't get in contact with the recruiter, well, then you run the risk of saying you didn't really mitigate your damages. You didn't make a reasonable effort to mitigate
I see.
this.
Okay.
So we're gonna reduce the amount. You have an obligation as an employee who's let go to at least try to find another job and send out some job applications. So this falls on the if there was a lawyer, this falls on the lawyer. They should have advised their client that this would come up, and you have to make efforts. There's no question about it. Whether you accept the job, that's a whole other story. But you have to show that you're making an effort to find another job.
Okay. I guess I would ask for an employee who finds themselves in a situation like this after wrongful dismissal. First thing you do is be very obvious about the fact that you are looking, as you just said, for something else so you don't find yourself in a situation like this.
Yeah, absolutely right. And, and many times the question I always get is sometimes the employer knows that they're in the wrong, and when they let you go, they offer you a package when you're leaving. And one of the key points there is there, I always ask, is there a clawback? Which means, are they saying if you find another job over the next year and a half, we're going to claw back 50% of what we're paying you, or we're going to claw back 100% of what you're paying you? Or sometimes there's no clawback at all. And that's something that you should know also, because what some people say is, well, look at this, I can get another job and I'm still going to get paid from my employer. So all of these different, there's so many different factors involved when you get let go. it's important to know what all the different aspects of what the offer is, what it entails, and what happens if you do find other work, or if you don't find work. Does the offer depend on all these different factors? And that's how you evaluate something. And risk also becomes a big part of that as well.
All right, I want to get into the other story that we're going to talk about today, because this is something very much in the news. A lot of companies now, we've talked about this before, asking employees to come back to the office. Employees, in some cases unions, saying this is unfair. Well, there was a judgment, you say, a few days ago, and this involved TELUS. So what happened here?
Yeah, it's in Quebec. So what happened here was the employer there was a unionized group of employees, and they called them back to work 3 days out of 5. Obviously, they contested, and they said, "Hey, no, don't want to do that. That's not fair. We have writing here. We have a collective bargaining agreement, and there's a lot of places where it states that we are remote working. We're allowed to work remotely. We made decisions based on that. You can't just call us back." And the courts ended up deciding, and this is what people should take from this, is that does the employer have the right to call employees back? Yes. Okay. Yes. That's the main rule. They can call you back unless the terms of your employment have changed, where remote work now becomes a fundamental part of your contract. So unless you have that in clear writing, where the job is a remote position, unless you can see that, and they alleged a whole bunch of promissory estoppel. They're talking about the fact that there's conversations about it being a remote job, and they couldn't get around what the court decided was, if it's not in writing, okay, or if it's not become implicitly implied that this is a remote job from now, if you can't do that, well, then you run the risk of the employer being able to call you back. They have to give you a lot of notice, sufficient notice for you to make arrangements in your personal life, right, whether that be changing schools or daycares or even moving again. But there's no question that the court, this is a big decision for employers. They really reinforce the fact that employers do have the right, fundamentally, to call back employees, since COVID or whatever the case may be, since that remote work was offered to them in the first place. They have the right to call you back unless you can demonstrate that your contract has now changed, and remote work is a fundamental part of the contract that you have with your employer. So basically, if you want to take anything from this, it's a win for the employers. It's a win for them being able to call employees back to work. Now, this is just one case. There are many cases where they were not successful. But, they reiterated the fact that employers have discretion to call back employees unless the new remote work has become, a part of your contract. Right. It's a condition of employment.
So I guess my only question would be, you kind of touched on this, does this or could this potentially set a precedent? But there are other cases, and I guess they're all judged on their own merits.
Yeah, absolutely. And what's funny is every case is so unique with the facts, right? What was said, which manager said this, what was said at the conference of the employees. There's so much that goes into these judgments. But, when they deliver their judgments, they make statements, and some of these statements can be used and as a precedent. And in this case here, if you want to take something away from this, it's basically like, at the start, fundamentally, employers have the right to call you back. Now, if there's stuff there that would prevent them from doing so, great, you can make your case about that. But that is where it starts, right? They do have the right, the discretion to call employees back that they once upon a time allowed them to work remotely.
We leave it at that. Chris, thank you so much. Appreciate it.
Thanks, Aaron.
I'm Dylan Playfair.
And I'm Tyler Smith.
We're putting loneliness in the penalty box by talking to some of our favorite athletes about the importance of friendship.
This is Bromance.
Bromance is brought to you by Charm Diamond Centers, proudly Canadian-owned and operated. Charm has been part of your love stories and bromances for over 50 years.
And you can find Bromance on the iHeartRadio network or wherever you get your podcasts.